Let's go ahead and get started. Good afternoon, everyone. Thank you so much for joining our monthly webinar. Those of you that have been coming to these for a while now, I just want to thank you for continuing to support us and to join these webinars. I really, as I always say, every time that I get an opportunity to share one of these webinars, our goal is to help you know what's going on in the 340B program, manage your 340B program, be prepared for what's coming as it relates to your 340B program. If you are new here, we do these once a month in order to educate and provide a ton of value to those of you that are managing 340B programs and 340B leaders across different fields of providers, consultants, etc. With that said, my name is Anthony Velasquez. I am the Chief Product Officer here at PharmaForce. We are a 340B third-party administrator in the space that works with providers all across the country, from clinics to large IDNs, in managing their 340B programs through technology and platforms that help them to do that in a compliant and optimized way. Okay. Let me just say the news as it relates to the 340B program continues to be breaking and bigger every single time that a new lawsuit or change or policy position is announced. So we are not short on topics and changes as it relates to the 340B program. If you're like me, who has been around the 340B program since 2011, 2010, right after the Affordable Care Act, you would probably recognize that there was a season at the beginning in those years where there wasn't a lot of activity, but that is not the case in these last couple of years. And I want to spend some time today just going through some of the big policy changes, lawsuits, and other things more broadly going on in the 340B space. Again, to help you who are managing 340B program learn how to view that in a way that is helpful and preparing you for those changes. My background is that I started on the covered entity side. I've worked at a 340B program at both a grantee and a large hospital, and then joined a third-party administrator about 8 years ago. So I have kind of both sides, and I like to include some of that perspective in the discussion topics. Let me also say, I don't think, and anything I'm going to say, the 340B program is not going anywhere. The 340B program is an immense safety net program for providers. The 340B program continues to be more important than ever, especially now in this sort of era of healthcare where health systems are struggling to keep the doors open, are struggling with reimbursements, are struggling with staffing shortages and so many things. And the 340B program is that lifeline that it was intended to be since the beginning and the intent of the program. So I try not to be speculative or hyperbolic in anything that I'm sharing. My goal is just to share the facts of what's going on and to help you process it and navigate with certainty in what is coming. All right, so as we get started, let's go through the agenda. Today, we're going to tackle four major sort of news items at a high level that involve policy changes, lawsuits that have had results come out, and how those things are going to impact you on a day-to-day basis as you manage your 340B program. So number one is manufacturer restrictions. That has not gone away. That continues to be a challenge for 340B providers in managing that. There was a decision in West Virginia that might have significant impact going forward on that. We're going to talk about the rebate model. The rebate model is not going away. It's been paused, but there is a lot going on there that I want to break down and inform you. We're going to talk about this huge lawsuit of AbbVie versus HRSA and the patient definition that I think will be really interesting for you to hear about and for us to dissect here. And then lastly is we're going to talk about a win for hospitals that are subject to the GPO prohibition. We're still a lot to know there, but we'll break that down. So again, thank you so much for joining. I hope that you get a ton of value from this content. So, manufacturer restrictions. We are now 6 years in to manufacturer restrictions, and the uncertainty remains for many 340B providers. This continues to be a thorn on their sides of managing manufacturer restrictions on a regular basis due to the fact that things seem to change and things happen differently state by state. So, if you are a multi-state covered entity, managing these manufacturer restrictions is very, very difficult. I see someone has a question. If you have questions, please put them in the Q&A and we'll have a Q&A at the end. So there's a function there. Feel free to use the chat function and share any comments, any feedback as well during the presentation. And I will allow time at the end for Q&A and even to come on live. So if you want to come live and discuss and ask me a question, I would love to do that. So please put your questions in the Q&A, add comments on how you're handling, what your thoughts are on these different topics. Those are really helpful to keep the conversation going. Okay, so again, 6 years of manufacturer restrictions that have not received full clarity. If you remember, manufacturers started this back in 2020, and we thought that there was going to be some resolution early on, and it has not, and it has just drug on, for years at this point. Litigation has not resolved this. If anything, it has muddied the water even more, because the courts are now ruling, and some of the early cases, the courts rule in favor of states who are taking action by passing state access bills. So these are bills that allow for that essentially force manufacturers to do what this 340B statute says, which is to provide 340B pricing to providers. These bills from different state legislatures have then been challenged in courts, and the 340B providers or the states that are passing these bills for the benefit of 340B providers and their constituents have seen early success in ensuring that these bills are not only pass legal tests, but are also enforceable, as these bills contain penalties as part of them. So there is a bill in the West Virginia one, for example, where there is a $50,000 penalty per violation to the manufacturer for not providing 340B pricing on a specific package that is purchased by a covered entity. So early on, those things have been pro the states. They have been very, very helpful. Have been a huge positive impact for providers in those states. I have been very, very vocal about my support for those bills and our support for those bills, which have been very helpful in helping providers recover the 340B savings that was initially lost. The challenge right now is that some states are then facing the opposite, which is that the bills are deemed non-enforceable, which is what we're going to talk about. The bills do not resolve the operational burden that is real and ongoing, which is in some cases you still have to provide the claims, and you're still providing the claims, you're still pulling that and submitting that and monitoring pricing and then losing pricing and then fighting to get your pricing back. And a lot of that is now the new norm. So what started as hey, this is something that we're going to push back against, this is something that we hope HRSA will intervene, has now become the new norm in the 340B program, and providers are having to manage this on a regular basis. As far as we can see, there's no end in sight without legislation or clarification from a legislative level. the courts are interpreting the statutes, but really it's Congress that can fix it. And we've talked about, I spent the probably the entire summer last year talking about several bills that were in Congress that were being considered to sort of staple or make more firm that 340B providers could use the 340B program at any contract pharmacy of their choosing. So, anyways, that's sort of the background story that I'm sure all of you live on a day-to-day basis. I talk to providers that say it takes them 25 to 30 hours just to manage their manufacturer restrictions and submissions on a weekly basis that had never existed before. So this is very painful for a lot of covered entities. Some of us that are technology providers have helped with providing tools and ways to submit that data automatically and in a more streamlined way, but it still is something that requires a lot of oversight and management. So, with that being said, what has happened recently? So, this has just happened very, very recent in the last week. This actually happened in the last week. Is there was a decision in West Virginia where the courts deemed that the law in West Virginia is essentially non-enforceable, and essentially the states cannot enforce this particular state bill. And this particular state bill had that same language in it that would allow providers to buy drugs at 340B pricing, and manufacturers were supposed to provide these drugs at 340B pricing. And then we got this ruling that essentially made it that the penalty attached to that violation of not providing the drugs at a 340B pricing is essentially not enforceable. So this is what we will consider a loss for those of us on the 340B side, those of us that believe that the 340B program is clear, that manufacturers are to provide 340B pricing for providers, regardless of what contract pharmacies they have in place to serve their patients. So again, many providers rely on these protections. This is one of the first case that sort of shifts the momentum in the opposite direction in a major way. We don't know what's going to happen. Post this, there was a decision later in Maryland, which is under the same Fourth Circuit Court, that essentially rules similar and referenced this West Virginia decision as well, that puts those state access bills at risk, just because, not that it changes the law, not that it says that the law is not valid, but it makes it where the penalties are not enforceable. I believe in the West Virginia bill that would have been enforceable by the State Board of Pharmacy, and that is now at risk and in question. If you are a healthcare provider, if you're a 340B provider in West Virginia, you're ultimately right now waiting for anything that changes as it relates to the letters from the manufacturers. That is still the source of truth. The manufacturer letters that are posted at the 340B ESP website, or for those manufacturers that are going to start doing that through the Calderos Truzo platform, those letters are essentially the source of truth that you should be looking out for in how it handles offering 340B pricing in your state. So nothing else can be deduced from this decision. It's very, very early on. We haven't seen anything else as it relates to that. And we'll be monitoring this. But the consensus is in the industry that this is something to be watchful, especially for those states where these state access bills and state protections have been a huge success for 340B providers, a huge breath of fresh air if you are in those states. So more to come on this. Be on the lookout. We're going to keep talking about this. There's a lot of great reporting around this. This reinforces the need for further advocacy for the 340B program across the board. There are states that are still pending passing these state access bills, and we hope that this doesn't cause them to not push those legislative bills forward at a state level. So that's what's going on as it relates to manufacturer restrictions. That is still a challenge, unfortunately. All right. I like to say that these are the two things that are, the two things right now that are the sort of biggest challenges and biggest changes to the 340B program. If you have been in the program as long as I have, it is a combination of manufacturer restrictions and the rebate model. I'm not going to go through all of the history of the rebate model. You can go to our website under resources and webinars, and you can see some of the breakdowns that I've done in the past about the rebate model. We've done a ton of these, especially at the end of last year, preparing for this. But as you all know, everyone was as ready as we could be, given the amount of time that was given, was ready for the rebate model at the beginning of 2026, and that was delayed by a court decision. So 340B is now living at the hand of the courts, unfortunately, the mercy of the courts, and it's an unfortunate way for the program to be managed. But again, as I said, the program still is a lifeline to many healthcare providers across the United States and across the healthcare system. So the message here is the 340B model is still coming. So that work that we all did, that you all did, in order to be prepared for that, is not wasted. And if anything, I think that the industry at large is more prepared, or is now more prepared than ever, should the rebate model come back. So here's what we know. We have gotten indications that there's strong indication that this is going to be rolled out again at the beginning of 2027. So we should see now a longer time period of announcement from HRSA that is required, and this was sort of one of the reasons why the court essentially put a hold on this whole thing, was because HRSA couldn't prove that they gave providers enough time to prepare. And right now, there's a belief that HRSA will announce this with an ample amount of time. Ample amount of time could be 90 days or a little bit longer. Currently, as we're sitting here, there is a RFI that is out related to the rebate model, where covered entities and those in the industry are asked to participate in informing what are the challenges to your program as it relates to the 340B program. That has been extended to April the 20th. So um, it is April the 15th. So April the 20th is the end date. So if you haven't done that, if you haven't commented on that, if your covered entity hasn't done that, I want to highly encourage you to do that. Highly, highly encourage you to do that. I know that there is yeah, I know that there's from the last, sort of comment period, many of us felt that nothing really changed, but I would just encourage you to do that if you haven't done that. Again, that's been extended to April the 20th. So please go, and you can do that through the HRSA website. But the rebate pilot is coming back. It is believed that the rebate pilot is coming back in a form that's very similar to the pilot. Sorry, the new implementation come back in a form similar to the pilot. The indication is it's not going to come back as a pilot. If you all remember, this was a 1-year pilot that was supposed to start in 2026 and at the beginning of 2027, and then be reevaluated. And there was a whole process and where providers could provide comments on how things were going. But that essentially has changed now, and I think there's consideration for a full implementation of a rebate model that's no longer in the form of a pilot. That changes a lot of things. Number one, it sort of closes the door on the potential of the pilot essentially going forward, being live for a year, providers sharing how expensive it is, administratively burdensome it is, how it requires covered entities to hire more resources to manage it, and hurts covered entities' cash flow, and all of the things that those of us that work with providers know will happen with the implementation of this. And it takes it and potentially moves it from being a 1-year kind of trial period to a more permanent solution going forward. I think that the rebate model is going to come back in some form. The final form, we don't quite know. But what I would say is I think that providers are as prepared as they can be, based on a lot of clients that I've talked to. A lot of covered entities that work with us are prepared for this whenever it comes, but are also very concerned. Are also very concerned and hope that it doesn't come. So that's why sharing your comment. That's why going to HRSA and getting your entity, getting your legal team, your compliance team together to submit a comment is very, very, very important. There was a report actually out that there were some advocacy groups that were submitting duplicate comments, sort of, pro the rebate model. So you want to go out there and work with your team to submit that. And again, just continue to be ready for that whenever it comes. If you all remember, I was telling you that there were covered entities that were already posting out rebate analyst roles, and there were large IDNs who were thinking about hiring a full-time, a full FTE just to handle this because they expect this to be such a big, such a big thing to implement and to monitor. So again, just this is something to monitor. There'll be more information coming out right now. Submit a comment if you haven't done that already, and share how this will impact your 340B program. I think there's specific questions about the cost, the administrative cost to implement this, and all of that. So you want to go ahead and respond to that because that is very, very, very important. To wrap up this rebate model, look, there's a lot of questions that remain. There's a lot of things that we don't know. The thing that you can do right at this moment is to make sure that you're engaging with your vendor. Make sure that your vendor is ready to support you. Make sure that you sort of dust off whenever this comes back, dust off the learnings of Q4 of 2025, where we all had to scramble to be ready for this because of the short timeline, and to remain flexible. Of this might not look exactly like the pilot, it might be a different form, but if it comes, we will be ready to adapt if that is what ends up happening. So we'll see. We'll see what happens with this, but let's remain informed on this rebate model. Okay. Topic number 3. This one, I will tell you, this was very surprising to me. Very, very shocking. I did not expect to see something like this, but it is, given other things that have happened in the last year or so, it kind of you can put two and two together that there's a reasoning for this. AbbVie, which is one of the manufacturers, has filed a lawsuit against HRSA, essentially saying that HRSA's 1996 patient definition, the one that we have all known and relied on for and have been audited on for, decades at this point, that it is outdated and it needs to be reviewed again. Essentially is what AbbVie is saying. This is a really interesting lawsuit because what usually has happened with this, if we learn anything from the manufacturer restrictions, is as soon as one manufacturer starts, the others follow along. So we will see what happens with this. I don't even know what essentially the courts can enforce HRSA to do at this point in order to impact a change in the patient definition. But essentially, the patient definition as we know it is under attack through this lawsuit. And so what does that mean? As you all know, the sort of general patient definition that we have used, that the patient is a patient of the covered entity, that there's an established medical record with that patient, that that provider is a provider of the covered entity, including providers that offer referral for consultation, that there's an EMR record of that covered entity, that the services the covered entity provided to that patient align with their grant, right? So the 1996 patient definition is essentially what's at the center of this lawsuit. And AbbVie is challenging HRSA's authority over that. AbbVie is also arguing that the definition is too broad and that it's enabling 340B abuse and restriction audits and all the other things. So there's a lot said in this lawsuit, and I'm interested if you're interested in reading stuff like that. It's interesting, interesting language, interesting stuff to those of you that have been in the 340B program. But let me say this: I think there is a Genesis connection here. This is obviously something that I think I'm deducing from the different, the different things going on in the market at large. But if you remember, a couple of years ago now, the Genesis decision was HRSA versus a covered entity, where HRSA found that the covered entity was not applying the 1996 patient definition properly, and there was an audit. And I think some representatives of that covered entity have joined some of these webinars, but that HRSA said, found that covered entity did not apply the patient definition correctly, et cetera. The covered entity pushed back and actually was able to win that suit against HRSA. That sort of put HRSA in an interesting situation of ability to enforce. And HRSA came out and said, we're still going to use our 1996 patient definition. That's what we're remaining with. That's what we're doing audits with, and that's what continues to be the standard in the market at this moment. At this moment, if you are audited by HRSA, it will be based on the current patient definition. So you want to make sure that your program is abiding by that, operating by that, because nothing has changed. So you want to follow HRSA, you want to follow what the HRSA guidance is on that. So why this matters? So courts, are challenging HRSA's authority, and HRSA's authority has been sort of challenged in many different ways. This is a very, very big case, one that I would encourage you all to keep your eyes on and follow, because this will certainly be something that could lead HRSA to make some changes, and we don't know. We don't know what that will look like, but I am a firm believer that 340B covered entities are strictly abiding by the 1996 patient definition, that the 340B covered entities care about ensuring that every single prescription that's audited meets a clearly defined patient definition, and that's happening on a regular basis. The lawsuit is alleging something else. So what does it mean? So here's some of the, here are some of the sort of specifics. So it says that a prescription qualifies for 340B pricing. This is sort of the AbbVie proposal, is the prescription qualifies for 340B pricing only if it directly tied to the care provided by the covered entity, number one. Number two, the patient had a substantive clinical encounter. Number three, the patient was seen within the past 12 months. Number four, the provider is managing the condition prescribed, actively managing the condition prescribed. I don't know about you. I would love to hear your feedback. Actually, I would love to hear you guys' feedback on this, because, in my opinion, that doesn't differ in practice from what many providers do today. Hey, I get it. There might be something here and there, but in my opinion, it doesn't impact significantly. I see a comment on number four as it relates to referral. That is correct, Danny. Thank you for that comment. That is the main, and as you guys are sharing that comment, that was my first thought as well. However, the the current patient definition, even if you are doing referral for consultation, you're getting that progress notes back and obtaining that progress note back for the primary care provider, for example, in order to continue to monitor the health for that patient at large in a primary care context, I think could still be defensible. So we'll see. But again, I'm curious to hear your thoughts. So please post them in the chat. I'm curious what your thoughts are as it relates to this, to what AbbVie wants to change, and maybe that is the goal, is to target referral prescriptions specifically, and that could be the goal, that it is targeting referral prescriptions specifically. So again, I'd love to hear your thoughts. Put them in the chat. There are some, yeah, there are some covered entities. I would say at large, most covered entities do a 12-month look back period. Some others have other things in place, but I would say at most covered entities do a 12-month look back period. So, anyways, very interesting topic. Okay, let me say a couple of things. Don't make any changes to your patient definition based on just this lawsuit. Okay, make sure you're educating your leadership team, your compliance officer, your 340B committee, if you are part of a 340B committee about this. Evaluate your program risk. One of the things that we have looked at is some data just to see what kind of patient definition is in place for some of our entities as it relates to this. But I would just say, evaluate your program and evaluate your policies and procedures. That has never hurt, and it's something that covered entities do on a regular basis. Okay, so that is that on the patient definition. All right. Now, this news is very, very big and very specific to those of you that are hospitals. So if you are a hospital and you are a hospital subject to the GPO prohibition and you are listening on this webinar, this is news for you. There was a case where Premier was challenging HRSA. Premier, the group purchasing organization, was challenging HRSA's authority as it relates to the GPO prohibition. And essentially, what the GPO prohibition does is it says that um, hospitals that convert to 340B eligibility and are subject to the GPO prohibition now have to get a WAC account so that their first purchase, the first sort of neutral purchase, is at WAC, at wholesale acquisition, which is no discount. And that product can then go to a outpatient setting or an inpatient setting. But the first package that you buy is done at WAC. So if a bottle of a drug, it's $1,000 at WAC and it has a 20% discount at GPO, the current GPO prohibition would say you have to buy that at WAC, and then you can administer that in a outpatient setting, 340B setting, or an inpatient setting for GPO. So hospitals on a regular basis, on a yearly basis, end up shifting a significant amount of their purchases to a WAC account as it relates to having a three-way split of 340B, GPO, and WAC. And this is part of managing a 340B program. This is managing a 340B program in a mixed-use setting or a split billing setting. It is one of the most critical things that you have to do in that setting is to monitor your WAC spend, your WAC impact, your percentage of WAC, the amount of NDCs that you're buying at WAC that you otherwise would have bought at GPO at a discount. And so this is a common practice for most providers to have to manage. This particular lawsuit seems to indicate that that could be overturned and that the GPO prohibition will no longer apply and that hospitals that are subject to the GPO prohibition. So if you are not subject to that, if you're a critical access hospital, a critical access hospital, a sole community hospital, for example, you are not subject to a GPO prohibition. So this doesn't necessarily impact you. But if you're a DISH, a children's hospital, etc., you are subject to the GPO prohibition. And therefore, this could be really, really big news because it could unlock a significant amount of savings for hospitals that could buy those drugs at GPO. So listen, this is not settled yet. Don't change any policies. I got text messages from different clients and different folks in the industry saying, "Hey, what should I do? Should I change?" Don't change anything yet. There is an appeal period that we are waiting for, where HRSA gets an opportunity to challenge that ruling and fight back, and we have to wait for that to see how that's settled. I believe it is 60 days from the announcement of that HRSA has to file an appeal. And if it doesn't happen within that 60-day period, then we are in a different territory. So you want to keep an eye on this if you are a hospital, because this could be huge, but you want to wait for HRSA's guidance on how to proceed with this. Please, please, please do not make any changes to your 340B program based on this. Please. The GPO prohibition is currently enforceable. It is currently what HRSA is abiding by and what they will audit you if you are going through a HRSA audit. So Do not take anything that I said to say that this means you can go and now change your practice. It does not say that. I'm not saying that. I'm just sharing with you the lawsuit, the facts of the lawsuit, but now there are additional steps that need to happen before anything can change as it relates to that. So I don't know how many of you think follow this or saw this or think this is a really big deal, but this is a really big deal, in my opinion. I have worked in managing 340B hospitals, and wax spend can be very tricky to manage if you have infusion centers and other places where you're combining multi-dose vials and all these other scenarios. So you want to keep an eye on this. This is very, 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 very important. It could be a huge win for providers if this was overturned. If this was overturned, essentially what it will mean in practice is that you could potentially go from a three-way split of 340B GPO and WAC to a two-way split of 340B and GPO. So this could be huge, and it could unlock a significant amount of opportunities of savings for providers that are now being spent at WAC in order to comply with the GPO prohibition guidance. All right, so here's the key takeaways as we wrap up. Manufacturer restrictions are here. You need to be flexible. You need to know what's going on. Work with your vendors, your TPAs, consultants if you're using a consultant to monitor this this is literally different on a state by state basis. So you want to manage this. You want to monitor the letters that you're getting and all of that. The rebate model is coming. Be on the lookout for that. It's already April 15th, tax day. I think today is the last day. Hope you fire taxes. But this is coming. And before you know it, it's September, and we get a letter or an announcement from HRSA that this is starting on January 1st, 2027. So be on the lookout for that. This patient definition is it's a really interesting lawsuit. I don't know how long it's going to take for anything to be heard on that, and so who knows what's going to happen there. But these are all things to be monitoring. The bottom line is this, like I said, and I started this, the 340B program is more important than ever to entities and to providers. Every single dollar matters in order for you to stretch your scarce federal resources. Being knowledgeable and prepared is more important than ever. So you want to know what's going on. That's why I'm so thankful to see so many of you on this webinar, because you're educating yourself, knowing what's going on so that you can inform your teams and your leadership teams. CEs need partners who are agile and informed and ready to evolve. So make sure that you're talking to your vendors, make sure that you're talking to your partners, and that you're strategizing for the future as these things come forward. All right, so here's a couple pieces of information about us. If you're interested in following us on any of these social media channels, I encourage you to go on LinkedIn, follow us. You'll get a lot of information there. You can get in touch with us if you have any questions. If you want to reach anyone on my team, or even want to share something with me, you can send it to the sales at the Pharma Force, and the team will make sure that I get that. Here's some upcoming conferences. So we're right now, some of our team members are at the Beckett's, the Becker's CPO Summit. There's a couple more conferences coming up. The Summer Coalition in July is right around the corner. I will be there. Many from our team will be there. So as we wrap it up, again, I want to thank you for joining. I hope that you found this insightful and helpful. I will do some Q&A now before we wrap up. So I know there's a few questions here. So all right. So let me look at the Q&A section. All right. Wow. Okay. I literally have an anonymous attendee that left a multi-paragraph question. I'm going to try my best to answer this. What are your thoughts on HRSA disregarding the comment that have been submitted by several patient caregivers on the rebate program? I am writing in response to the request for information on the proposed 340B model pilot. As a patient caregiver, I believe the 340B program should clearly and measurably benefit patients. Too often, patients are not told when a medication is purchased at 340B, and there is little transparency into how these savings are used. If HRSA moves forward with a rebate model, it should prioritize transparency, accountability, and patient benefit. Any new structure should make it clear whether savings are reaching patients are helping reduce out-of-pocket costs. Patients deserve to know when the discounts are applied, whether those savings are lowering their financial burden, and strong oversight. Yeah, that's good feedback, anonymous attendee. Yeah, I think those are valid points. What I would say is a lot of the 340B programs that I have been a part of when we've done, impact profiles, for example, is what we would call them, is that the 340B savings help the health system or the clinic at large to offer services and to keep in some cases the doors open of the health system. We have we have some entities that are doing cash card programs that are extremely generous and beneficial to patients. So we I know a couple of entities, very large organizations that are doing amazing work in passing 340B savings through cash card programs. So if you're not doing that, I would encourage you to look into that. But I think your points are valid. Thank you so much. Will you share the link to post comments for the rebate model? Yeah, we can probably do that. So if anyone on my team is out there in the chat, if you can go to HRSA and there's the site to submit the comments, please post that in the chat. Okay, what happened to FQACs having their own definition of a patient? We use 2 years look back. I don't think anything happens to that. I think as long as you have a strong policy and procedure case as it relates to the 1996 patient definition, that is something that certainly seems to be within line. This was a canned comment that was copied and pasted by several patient caregivers. Okay, thank you. Got it. Okay, yep, that makes sense. All right, cool. So thank you for those questions. Let me stop here and ask, hey, does anyone want to ask any other questions? I would gladly unmute you and you can come and chat with me and ask any question that you want. All right, I see two hands up. Let's give this a try. I'll do one or two. And then we can have a conversation. Okay, Sydney McClendon, are you there? All right, hold on. Hold on, Sydney. Um, okay, Sydney, are you there? All right, we don't have Sydney. All right. All right. Tim, are you there? All right, Tim Ka, are you there? I see your hand is raised. All right, Tim, going once, going twice. All right, now moving on to Michelle. All right, so here we go. So Michelle, I'm going to call on you. All right, third time's a charm. Let's see. Let's see if we can get Michelle. Michelle Darnell. Michelle, are you there?
I am. Can you hear me? Can you hear
Michelle, I
me?
think you're talking, but I can't hear you. Excuse me.
Huh, good.
I think you're talking, but I can't hear you.
Let's see if I can you hear me now?
Oh, you can hear her. Okay. So then there must be something wrong with me. Hold on.
Can you hear me?
Yes, I
Can you?
can now. All right.
Okay.
Oh,
So my question is based around the
Michelle,
rebate
real quick.
model.
Michelle, real quick. Who are you with? Who are you
Okay.
with in which role?
So my name is Michelle Darnell. I am with Sandy Cedar Health. My
Okay.
role is the Director of Business and Optimization. And my
Okay.
question is wrapped around the rebate model
Yes.
that will be coming.
Yep.
Probably most likely, we have no idea, but I would assume run by Beacon or that
Yep.
platform, possibly.
Yep. Yep.
Um, do we have any idea if it will be a WAC and a 340B rebate on the back end?
Uh,
And the next question is it going to be all the 100 drugs that they've talked about from now to 2030?
yeah. So let me answer the latter question, because the last I read is that the 2027 in 2027 the list expands. The IRA drugs that are negotiated by Medicare expands, And the last I have heard is that the goal, or what HRSA is trying to do, is to cover that entire list, which includes GLP-1s and some other really important meds to patients. So that is, yeah, that's the answer to that question. Is that there are nothing is final, Michelle. So nothing that I'm telling you is anything that I have insight to or any special information other than what's been reported. But the report is that they will, in 2027, when they expect this to sort of be launched, if it goes that way, it will include a lot more drugs than were expected in January of 2026, which was relatively smaller compared to what's coming. So that's the answer to your latter question. The answer to your first question is, as of right now, there's no indication that it wouldn't be what the pilot stated, which was the difference between WAC and 340B. So we don't know any different news right at this moment. So the pilot is the best, closest idea that we have of what a new rebate model could look like when it's official and it's announced.
And what can we do to all get together? I mean, this is going to hurt entities. Um,
Yes.
and what can we do to all get together to show that the rebate model that they tried to put in with MFP and all the problems and the money that we were getting paid that we shouldn't get paid,
Yeah.
um, or vice versa,
Yeah.
that it was just like a flop. I mean, what can we do to push this across other than write letters?
Yeah. Unfortunately, the only thing you can do right now from a taking action perspective is to make sure that you're adding a comment to the currently open um, request for information by HRSA, specifically in the question as it relates to how much this is going to cost to even manage. And it's only 5 days away, and if you haven't done that already, that would be probably difficult to turn that around. But that's the only thing we can do at the moment, Michelle, unfortunately. Um, otherwise, unless HRSA has you know, some sort of miracle happens and they decide not to enforce a rebate model, that is the only option that's on the table right now.
Thank you.
Yeah, no, thank you. Thank you for the question. I really appreciate it. All right. Well, hey, it's 2:47. Thank you so much. I won't take any more of your time. You guys have been super gracious with me, and thank you for joining. You will hear more from us on the next topic. We're going to keep talking about these things. We're going to keep bringing light, encouraging advocacy, and making sure that we're all fighting for the 340B program and how important it is to providers and patients. Thank you so much. Have a great rest of your afternoon.